Hello, friends. All of you might be knowing today, if you want to buy a property, it costs lakhs or crores together. Because of this, many people wait for their ancestral property share. And many daughters also ask an important question: do I have a legal right in my father's ancestral property? Yes, daughters do have the equal rights. There are some exceptions to that. There are certain situations where a daughter cannot claim a share. In this video, I'll clearly explain when a daughter is not entitled to ancestral property as per law. So, watch till the end. This will save you from the serious legal confusion. So, today I'm talking about only Hindu women and Hindu ancestral properties rights. I'm not touching the Muslim or Christian women's right. Okay. So, be specific to Hindus. If you see the legal background, like before 2005, earlier only sons had right in ancestral property. But after 2005's amendment in Hindu Succession Act, daughters and sons are treated equally. A daughter is co-personally right by birth. That is what is being changed in the new amendment. Now, daughters are also having the equal rights exactly similar to son. By birth, they will get the rights now. Okay, so that is the major change that has been taken place in the Hindu Succession Act in 2005 by amending it. However, rights does not mean that it is an unlimited right. There are some exceptions to it. Let us see one by one. There are some 6 to 7 points are there which I want to explain it to you. In which situations a daughter will not get the right on her father's property. The first situation is this: father is alive and property is self-acquired by father. So that means if the father is alive and the property is in his self-acquired property, he has earned it and then he has purchased a property. But in that situation, nobody will get the right. That is his own property. He can sell that property, or he can gift it, or he can write the will on the particular property. Basically, he has the full right over the property. Nobody can claim it, including the daughter. The next situation is this: father make a will for his self-acquired property and he died. In this situation, that particular property belongs to the person which is being written in will. No children, even son or daughter, cannot claim that particular property since it is a self-acquired property and it is being given through a will by the original owner, who is the father. In that situation also, a daughter or a son will not get any right on that particular property. The third particular situation is daughter signed a release deed. If during the partition, if a daughter voluntarily put a signature on the release deed saying that I don't want any property, I'll just take the money instead. In that situation also, once it is being signed and once it is being registered, a daughter cannot claim on the property that is being released by her. After giving the release deed, again she cannot come and then claim on the property that is being already released. Right? So in this situation also, daughters will not be having any rights over the property. And the fourth most important situation is this: a partition took place before 2005. The amendment has been taken place in the year 2005. What about the previous year's transaction, right? Or previous year's partition or the court order? Very important. If the ancestral property was partitioned before 2005 and sons were already enjoying it, the daughter cannot go ahead and then reopen the partition again. So basically, the 2005 Amendment Act is not retrospective in such cases. Otherwise, what will happen is, like, every woman will be having the right and then they'll go ahead and then file the case even though it has been partitioned much before, right? Nowadays, property's value is like reaching the sky. In this situation, everybody want the property, everybody want money. So, they cannot go ahead and then file the case for the property that has been already registered before 2005. The fifth situation is daughter consent in post 2005 partition. Even after 2005 also, if the partition took place and the daughter signed the partition deed, give her consent and accepted the agreement, and the property's partition deed is registered in the sub-register office, even in this situation also, she cannot claim the property later. And sixth most important situation is this: if the property was sold or gifted or transferred in any manner, daughter cannot claim the share. Because before 2005, daughter was not a co-person under Hindu law. So all these things happened through the amendment in the year 2005. So as I said, this particular amendment is not retrospective. So that is why, if at all property has already been transferred before 2005, then a woman cannot claim her right in the ancestral property. And seventh most important situation is this: if the property came to father by will or gift, right? Even in this situation also, that particular property will be considered as self-acquired property of the father. Then that property become his absolute property, not ancestral. During his lifetime, no children can demand a share. So these are the 7 major situations where woman cannot claim her rights on the father's property. So yes, daughter have the equal right like a son, but it is not absolute in these 7 situations. So my friends, if you need any these kind of videos, kindly write it in the comment. I'll try to bring it to you. Thanks for watching.